Right, to begin the conversation on constitutional amendment, let's take this background report by correspondent Oyeyemi Ajayi.
In the word of former Secretary General of the Commonwealth, Emeka Anyoko, it says, to achieve the desired transformation for the better, the country needs a system of government that not only addresses Nigeria's diversity, but is also based on a constitution that can correctly be described as the Nigerian people's constitution. These thoughts surely resonates with many who believe the Nigerian constitution should be amended. Over time, there has been a clamor for such with the belief that the Nigerian constitution is vague and doesn't reflect the reality of today, despite previous amendments. In this same line of thought is the 10th National Assembly, which has set up a 47-member Constitution Review Committee with a pledge to conclude the amendment of the Constitution exercise in 2 years. The Senate President, Godswill Akpabio, had explained that the 1999 Constitution needed a review because it contained many issues that should be put right. On his part, the Deputy Speaker of the House of Representatives, Benjamin Kalu, confirms that first draft report of the ongoing review of the 1999 Constitution would be ready in August 2024, while the final clean copy for presidential assent would be out in August 2025, noting that on May 29 or June 13, 2025, the final concurrence of state assemblies would be secured. Nigerians are expecting a better and encompassing constitution, which will indeed reposition the country's integrity within and outside its shores, and one that must be respected by all, either rich, poor, influential or not. Constitutional amendment could become necessary as a result of other societal dynamism, which includes changes in administrative structure of the country. The need to accommodate the interest of some segments of the society, especially the masses, aside changes in the societal realities amongst others. How encompassing can the amendment be? Will all grey areas of the Constitution be touched? And how effective can it be towards the growth and development of the country? These are some questions set for guests already seated in the studio now.
Thank you, Oyeyemi, for the background report. And we already have some of our guests here seated in the studio. Right now, we have in the studio Mazi Afam Osigwe, SAN, former Secretary General, Nigerian Bar Association, NBA. Thank you for joining us on Good Morning Nigeria.
Thanks for inviting me.
All right.
All right, and we have also been joined on the program by Yunus Ustaz Usman, also SAN, a legal practitioner. We welcome you to Good Morning Nigeria.
Thank you very much.
And from Port Harcourt, from Port Harcourt studio, Barrister Festus Oguche, a constitutional lawyer, has also joined us on the program. Good morning and welcome to the program.
Thank you very much. Thanks for the privilege of inviting me.
All right.
Okay, so you're welcome.
With him?
Okay, let's just start from the studio here, and let me kickstart the conversation with Mazi Afam Osigwe, SAN. Many Nigerians are actually worried that the preamble to the 1999 Constitution will only make meaning when all realistic concerns are adequately captured in the current review that is going on. We are set for yet another constitutional review right now. So what do you think the current process should be like?
We've operated this constitution for almost 25 years, and we still have complaints about the administrative structure, the fiscal structure of Nigeria, about the relationship of government with the people, about the bloated nature of the presidential system of government. And I think that more than any other thing, the constitutional amendment should be geared towards devolving more powers to the states, making for a government that is accountable to the people, ensuring that government at all levels are able to achieve the primary aim and objective of government, which is the security and welfare of the people, We spend so much money going through this amendment exercise, and people still express a lot of dissatisfaction. And then for me as a lawyer, it's also about doing some justice sector reforms that will ensure that the court systems are much more effective and efficient, and the people's confidence in the courts are just, people have more greater confidence in our judicial system to do justice. And then for me also, it's about also looking at the administrative structure of the judiciary, the Federal Judicial Service Commission, the National Judicial Council, the relationship between the leadership. So for me, these are some of the things we should look at. The safety of the people, policing, as the federal government has clearly kick-started the conversation about having state police, the desirability of it, and if we are going to have it, what kind of structure do we put in place? What kind of checks and balances do we put in place to ensure that people's fears of likelihood of abuse by state governments are assuaged, so that these people will also be able to live under such a system if in the event it comes to be, and then people are able to utilize the instrumentality of the law to check or challenge any abuse or attempt to abuse any of these processes. We have to make the constitution work. The argument whether we, the people, the preamble to the constitution is a fraud, I think we have gone beyond that. We have had 25 years of operating it. We remain a nation. Let us work out a constitution that gives satisfaction to the people, that addresses the core issues between the states and the federal government, and then between the local governments and the states, because the local governments are holding the short end of the stick with the joint account committee. There are so many amendments we should talk about. I mean, there are other contributors in the studio. So I should say this as a way of setting the tone for the conversation, speaking from my own point of view.
Okay.
All right. Thank you very much, Afam Osigwe. Let me get to Yunus Ustaz Usman. The House of Representatives, or the National Assembly, has itemized a number of issues that are on the table as far as this constitution amendment process is concerned. In your opinion, what are the big issues, what you may call the elephant in the room, that are not or that have not been itemized?
To start with, I was invited to submit a memorandum for the amendment, which I did. And let me tell you from the word go. Yes, we need amendments, but our problem has been that of kakistocracy. That is electing people who are not worthy to be there. Electing people who are not capable of running the affairs of this country. Electing people who are not sincere between them and their God. That is the main problem we have in this country. It's not really the amendments. It's not really the amendments. And unless these things are done with, whatever amendments we make is just what we call like a child's play.
But
yes,
laws are intended to shape the way we conduct ourselves.
Yes, I'm telling you, laws are intended to shape the ways we conduct ourselves. There is nothing wrong with this constitution really, except in some gray areas. But I'm telling you that our first prayers will be, when can we have people who are sincere? When can we have people who are not just playing to the gallery? When can we have people who will lead as those who led us in the first republic? That is the main issue. Now we'll come to the amendment. You see, if you are sincere about amendment, the first thing to do is to take holistically the recommendations of these people, the National Constitution, something under Jonathan.
Constitution Conference.
If you don't do that, anything you are doing, you are just playing to the gallery. Because if we take their recommendations, Nigeria, to me, will be okay. But if we don't, whatever you are doing, you are deceiving yourself. You are just not sincere to yourself. And then you look at it. Unless we come to elect people who are sincere, not to their pockets, but to lead the people sincerely, cannot get anywhere. And it is extremely difficult under the present Nigerian circumstance to get such people. For instance, there is no private candidacy. I recommended it. Unless you do that, money bags will continue to lead this country. And it is very, very difficult to have such people, because the money bags will ensure that that is not made part of the constitution. There are many people who will come and lead this country between them and their God, thinking of the day they will meet God. Those people are not money bags, but it's too difficult to get those people. And then if you go on, you go on. Now, the states are just existing in name. Most of the states, particularly in the north, cannot fend for themselves. So you need a sort of collapse. Make 2 or 3 states a state, and so on. Do you know every state now depends on the federal allocation? Is that how we should exist? If you are intending to serve the people and you turn the country to work sincerely, I think we need 6 composite states that can fend for themselves. No state can fend for itself now, really, except Lagos, the southern states, and so on. But then, because everybody wants to be governor or to be a senator from one place or the other, that may not fly. And if it doesn't fly, it's left between them and their God.
Okay, thank you. Thank you, Ustaz, for that. You have raised a lot of issues there. That the issue of the people, government, and also that the present constitution has no problem actually, but it's the people that are driving the constitution that is the problem. So let's go to Port Harcourt, where we have Barrister Oguche there, which is a constitutional lawyer. From the issues raised here, and a lot of people are clamoring for people-oriented constitution. What do you think about that?
Very much for the question. I'll first of all express my excitement at the intro, which echoed the words of the Senate President Fabio to the fact that the Constitution has many flaws and there are issues that has to be put right. I think that is exactly what it is. I happen to be part of the panel that discussed constitutional amendments, those areas that the President had given assent last year. And we had elaborate discussions on it. There were amendments relating to correctional centers, amendments relating to transmission of electricity, and we are beginning to see the result in Abuja State. And the correctional centers, I am not sure if there has been any improvement to the welfare of inmates or that any state has built any prison since then. But we now see the power of legislation and how it can be put into effect if you do get the things right. My first port of call will necessarily be that I'm not too sure if the National Assembly took its time to ascertain whether it is a very auspicious time to start this debate or to go into this process. I'm saying this because I wouldn't want a situation where the Nigerian population will look at the National Assembly as being totally unconcerned or indifferent to the plight of the people. There's hunger in the land, and we would have expected that at this period, the focus should be on making legislation that will alleviate the suffering of the people, the pain, the anguish, the deprivation. But be that as it may, having kick-started the process, and there's a timeline which Mr. Carlo pointed out, and which I think should not be part of a constitutional making process, particularly amendment. There shouldn't be any timeline. Nobody should be in a hurry to make a constitution. It is a very fundamental document, an organic document that touches on the lives of people. Over 200 and something million Nigerians, and it's not something that you put in a hurry. But then I will say again that in the making of this constitution, we tend to restrict ourselves to a particular procedure between the National Assembly, the Houses of Assembly, and the Presidency. I know that the National Assembly is composed by people who are representing the masses, so also the State House of Assembly having been elected into it. But I'm looking at the issue and importance of a plebiscite or referendum in constitution making. This is particularly so because of the challenge on the existing constitution, on its legitimacy. I would say that it would be a more valid document if the Nigerian people are involved. And they will tell you that there's nothing like referendum in the constitution, except in section 8 relating to boundary adjustments. But then you don't have to find a referenda or plebiscite in the constitution before you apply it. You don't look at all the constitution, except maybe the United States Constitution, Australia, United Kingdom. You don't find anything relating to referendum. It is something that is inherent in the democratic process. It is an attribute of the democratic system that if you're doing a constitution of this nature, at least to give some shade of validity to an existing constitution where the legitimacy is being questioned, you should involve the people, which is very, very important. And I also look at it from the point of view of the level of expertise, because the issues that are going to be raised in this constitutional amendment process relate to state police, the evaluation of powers, fiscal federation, electoral reforms, and judicial reforms. Now, if you look at those issues critically, they require some bits of expertise. And I am saying that the members of the National Assembly may not have that necessary expertise to make legislation in that area. Lawmaking is not just sitting down, deliberating, and coming out with provisions of the law. We had that experience in the Electoral Act where everybody believed, from the National Assembly to the last man on the street, that election results would be transmitted from the polling units directly. And when we came to elections proper, we found a different thing altogether. So it's something that requires a bit of expertise. All these areas, state police, devolution of powers, have been subject matters of research in the universities. For instance, the Faculty of Law of the River State University have touched on almost every area of this deeply and extensively. And I don't know how many times professors or the citadels have been consulted in these areas by the National Assembly. It's not just taking memoranda from members of the public, because expertise is required, for instance, to talk about devolution of powers, fiscal federalism. Unless you want to touch it at the surface, which will definitely create problems in the future. Professors are not just there to act as returning officers and rig elections and declare false elections. They are there for research. Unless we want to use them for a different purpose altogether, the citadels must be carried along. It's just like the recent action, and this attitude is pervaded across the West African sub-region. For instance, the ECOWAS Chief Justices of the ECOWAS community says they want to give a new effect to the ECOWAS treaty that will dampen or maybe reduce the power of the ECOWAS courts to enforce fundamental rights. How do they know? Are they international human rights experts? And they are moving towards that direction. And we find this problem in virtually every area of our human life. International relations, international communications, areas that require specific experts, some shade of expertise to shed light on them. I wish them very well though, but I think the problem on the ground is while they are doing the constitution amendment process, they should remember that there's hunger in the land and people are suffering in pain, penury, subjugation, and deprivation. Thank you very much.
Barrister Festus Oguche, thank you very, very much for your opening comments. And just while we were getting the remarks of Barrister Festus Oguche, the Deputy Chair of the House of Representatives Committee on Media and Publicity, Deputy Spokesman of the House, Honorable Philip Agbetse, walked into the studio. It's a pleasure to welcome you to Good Morning Nigeria.
Thank you very much.
You are also a member of the Media Subcommittee of the Constitution.
The chairman of the subcommittee.
Oh, you're the chairman.
Okay.
Yeah. All right.
So it's a pleasure to welcome you. A lot of issues, some raised while we weren't here and some raised while we were here. Electronic transmission of results, which came on board the last time. Well, Barrister Oguche has said it was something else by the time you expected that to come into effect. Issues of referendum have been raised, devolution of powers, resource control, independent candidature, and all of that. Most of these are not on the table for the National Assembly. Is there a reason, or you are willing, is this something you are likely to expand?
Well, thank you very much, and I want to commend his insight into some of these issues. But again, to look at it, the National Assembly is an institution. To say that people in the National Assembly lack the expertise, to conduct these activities, I think that is not totally correct. And again, to put issues in proper perspective, the members of the National Assembly are representative of the Nigerian people who went through the process and procedures of becoming representatives of the people. And when we are talking about the constitutional amendment, yes, we must give it to all of us, leaders of this country at every level, whether those directly involved in public service or through other means of leadership. We are all concerned about the economic situation currently ravaging the country. This morning, while I was on my way here, we are equally expecting, the members of the executive, the Honorable Minister of Agriculture and Food Security, and other senior leaders in government, to brief the National Assembly about what they are doing, to address the hardship in the country. So it is a given that the National Assembly as an institution, it's pained. We are concerned about the sufferings of our people because in the first instance, we are representing these people. So coming back to the issue of constitutional amendment, what we are trying to do, because over the years, we have seen, the National Assembly kickstarting these processes and never getting to the end of it. So what we want to do in the 10th National Assembly is to ensure that the taxpayers' resources that have been committed into these processes in the past, in our own time, we see to it that something is really done and we're able to deliver on our campaign promises. Virtually every Nigerian politician, who wants to be in power must have contested on the fulcrum of one of these issues: state, police, devolution of power, fiscal federalism, and the issue of inclusion of women. So we want a situation where these things go beyond rhetorics. They are no longer things you make as campaign tools. And for every nation, constitutional amendment is not a final thing. At every stage of human development, as far as people continue to yearn for better living, a constitution is actually supposed to be a guiding document that assembles the hope and aspirations of the people, that governs the people. And governance is a continuous process. So what we are trying to do at the moment is not going to be like a final document that will be cast in stone, as an everlasting document that will govern. As Nigeria as a country continue to evolve and modify from one state of life to the other, there will definitely be issues that will be raised. And coming back to the issue of state policing, recently, Mr. President and the governors met. This level of insecurity that we are being faced in the country, we've not witnessed it in time past. So maybe the framers of our constitution in 1999 did not envisage this level, and for that reason, they didn't discuss state policing in that constitution. So if today's state policing has become a major issue, that Nigerians must address in order to be able to move forward and to safeguard the lives and property of Nigerians, then that is what exactly we are going to do. So as a people's parliament, our interest is not just about, we have been elected by the people. No, we also, the process of lawmaking in the National Assembly gives room, to the input of experts, critical stakeholders, civil society, media, and everybody to be involved. And what we have done at this point is to say, yes, we have started the process. We want every Nigerian to be involved. And that is why we are giving the timeline and we are talking about it. And that's why we have a media subcommittee that will go around the country, that will go around all media houses to wake Nigerians and say, we have commenced this process. Those of you who want to have your state, those of you who no longer want your state, you want to come together as a region, please do come with your submissions before the committee. And, in time past, the National Assembly will spend 4 years, exactly the period of time that people are elected. When it is 2 or 3 months to the end of that assembly, you are talking about presidential assent and how to put the final document together. So what we are saying is that if all that we will be able to do at this point is to amend 7 critical areas of the 1999 Constitution as amended, then let it be our achievement that at this point in time, when this set of legislators were in the parliament, this was what they were able to achieve. not to say we are taking the entire document around the country, everybody is making comments, making inputs into the document. At the end of the day, it turns out to be the annual jamboree. Nothing is achieved at the end of the day. So that is exactly what we are trying to curb. So now when you talk about timelines, for what we intend to achieve, between the chairman of the constitutional amendment and, back to the statement by Barrister Festus Oguche, the chairman of the constitutional amendment is a lawyer. The Right Honorable Deputy Speaker is a lawyer. Myself, I'm also a lawyer. And in the National Assembly, even we go outside our own individual knowledge to engage the services of consultants and experts, who come, behind the scene to guide us. Okay. You can't talk about the Electoral Act and say because the Electoral Act was passed by the National Assembly and had the INEC decided to implement the wedding, the issue of electronic voting, you now pass a vote of no confidence that we no longer have the powers or the expertise to amend the Constitution. Again, the way the courts, the lawyers interpret, and the way the courts interpret, provisions of the law, we make the law. It is not our business, how these things, are interpreted by lawyers, and, judgments are passed by the court. But again, as a people's parliament, when we find that there are issues with the laws that were made in the past, again, we come back to look at it, and that is why we have room for amendment.
Okay, let me stay with you, because in the past there have always been the question of public engagement, that the National Assembly don't actually really engage the public, in the process, in genuine process. How do you intend to ensure that this time around the public is engaged extensively?
Yeah, you see, while it looks so much on the surface that it is a top-bottom approach, I can tell you that we are equally engaging a bottom-top approach, because we are trying to get things done in a very unique manner this time, to get best possible results. So the first engagement, before we even inaugurated the House Committee on Constitutional Amendment, we engaged the Conference of Nigeria Speakers. If you look at it in time past, the National Assembly will be able to do their best. Then when it gets to the state, you see that state assemblies, for critical issues like autonomy of even the state assembly and local government autonomy, the state assemblies would decline assent at that level. So what we are doing at this point, we started by engaging the state houses of assembly. The Conference of Speakers are involved. And from our engagement with them, we've told them, why not at your levels conduct public hearings? Why not go to the state levels to conduct public hearings, engage your people, have your own constitutional amendment committees at the state level to begin to engage the people on these critical issues. And that's why if you listen to the chairman, Right Honorable Kalu, he mentioned the focal issues at the moment. And again, if you look at the implementation of the Rose Committee report, there are also constitutional issues that without an amendment, you cannot also achieve. The parliament is also working on that. So, and it's an everyday process. Even if you go to the parliament today, you still see issues raised by members, on the issue on areas of the constitution to be amended. So it's a continuous process. So using that bottom-top approach, engaging the state houses of assembly, engaging the people, then we come back, we look at this document. When we have the first draft copy of the document, hopefully by August this year, that's the timeline we're working with. This draft copy will be presented back to the Nigerian people to say, these are the inputs we have received. In the event that we have omitted the input made by any critical stakeholder, please do come back to us between August and February next year, February 2025, when we also intend, to present another copy of the document before the committee of the House. And sometime May 2025, we intend to send this document to the various state houses of assembly, so that by October 2025, we now have a document, that has received the input of the larger population of our people across the country.
Which means that in local languages as well, you're going to, because besides the literate Nigerians,
yes,
what about the illiterate ones? Are you going to, speak to them on concerning this?
Good. Before now, what used to happen in the past, the entire committee will go to a region and they will engage the people. And what the chairman of the current Constitutional Amendment Committee in the House of Rep, Right Honorable Kalu, has done is to constitute, subcommittees Now these subcommittees will go to the various states. So if it means spending
They'll get
2
to
weeks,
their local communities
yes,
as well.
yes, all the 36 states, you know, to engage everybody, because we want a constitution for the first time that Nigerians will be able to be proud of, to say this is our constitution. We made useful input into this document, and all of us will be happy at the end of the day.
Now, is it safe to say, given what you have said, is it safe to say that these other issues that you have not itemized, referendum, devolution of powers, resource control, are they out of reach?
No.
And then the timeline, your timelines, would you consider expanding or extending if you are unable to do a thorough job leading up to that time? Because if you must meet that timeline, you may as well just, whatever it is that you put together, just because you have a time that is binding you.
You see, since the exit of the military in 1998, every issue being debated about the constitution since I was in college has been debated. We don't necessarily have new issues to be debated as regards to inclusion or exclusion from the constitution. There is virtually nothing new, you know, that we have not debated in past constitutional amendment conferences. The issue of Okuta panel report, the issue of a Ways Committee report, what have you, all these issues have been discussed. So even for a parliament that is not, I'm saying that even in the event that one is not willing to, you know, engage the people, we know the issues that are in the front burner of progress as far as the development of the country is concerned. And we are saying that these issues, as they have been brought, you know, some of these issues have been sponsored, you know, as bills even before the parliament. And we are saying, as people's representatives, there's no level. We have not shut our doors against people's input, because it's a democracy. The people have a right, you know, to bring in their views and opinions. And if everything Nigerians want, you know, and again, you know, it is not every instrument of lawmaking that must be included in the constitution. Our senior lawyers will tell you, we don't necessarily have to state every single thing, you know, in the constitution before we know that we have a good constitution. There's no way in the world that, you know, you band together a literature document and call it a constitution. There must be the very germane issues, the most critical issues, you know, that will form the basis of our nationhood. The very serious issues that should define, you know, the process of governance, and to give to our people, you know, things that safeguard, you know, their welfare, things that protect the future of our children. And that's exactly what we are talking about when we say we want to have a people's constitution.
Okay, thank you very much. Okay, let me bring in Afam Osigwe, SAN now. The issue of consensus now, it's really a major issue, because there is often the lack of consensus among political parties and interest groups on the need for specific amendments to the Constitution. This has made it difficult for the Constitution to be passed. So made it difficult to pass amendment through the required process. How do we begin to address that issue?
Lawmaking process itself is a consensus building process. The fact that you belong to the same political party may not necessarily mean you may support a position taken by your party, because you may want to look at it from your own ethno-religious or political consideration, or if you know this is not good for the people I represent or for my state. So there are many issues. So it's about finding accommodation, finding a provision that speaks to people's needs or your understanding of what your representation, the people you represent expect of you. So it's about making laws for the right reasons, and making laws that addresses people's fears and does not make a person feel that if such a law is made, may work hardship on either his own section of the country or his constituency or whatever. But the point to be noted, like Mr. Agbese, Honorable Agbese has said, is that if we really want to make laws that will stand the test of time, a number of these discussions have taken place, and Yunus Ostaze has referred to the detailed report of the Constitutional Conference that took place under the Jonathan administration. I'm not so certain that going to the states, going to constituencies will suddenly be. come up with a silver bullet or come up with such wonderful suggestions that we haven't heard before. Like he rightly said, many of these discussions have taken place. They are contained in so many documents. Are we really serious to make such amendments that will address this issue so that we don't keep wasting huge public funds or having public hearings that are never really hearings, that are just to gather political bigwigs, a question of who is able to get in there, people backslap, and then no real conversation takes place. So if we want to, we have enough material to work. We have enough professionals from diverse background in the National Assembly who can act as consultants, people who may have submitted memoranda to the National Assembly. We have to sift through some of these things to really understand what we need and then evolve a document that will address some of the challenges, or address some of the amendments that people have been yearning for. I don't agree, contrary to Mr. Oguche's position, about electoral things. Things about how results are transmitted are not constitutional issues. They can be found in an act. You can't load your constitution with just about everything. If you've seen the American Constitution, it's just a very small document, but the courts have breathed life into it through their judicial interpretations of the various provisions of the law. We have one of the most cumbersome constitutions in the world, and we are still crying. We are still can't operate it. We keep going back to amend it. Constitutions are written in such a manner that because they are supposed to address certain issues, and societies are in a continuous state of change. You allow the political and the judicial process to breathe life into those provisions. The American Constitution was passed in 1776. And it has now had too many amendments as you would expect in a document that is over 200 years old. We keep amending, we keep spending so much money that we don't have. And maybe that may explain why people think that at a time of serious economic meltdown, that rather than focusing on constitutional amendment, we should focus on putting things that will right the economy, put food on people's tables, addressing securities. But then again, the security architecture as contained in the Constitution may well help in addressing some of these challenges. So there's no perfect answer, but it's about governance, making sure that government does what a government should do, anticipating problems, finding solutions to them, and then the ones that have arisen, addressing them, building consensus, which is what the president did by having a meeting with the governors, not about going to the National Assembly and saying, we want to do this. Everybody sat down first and agreed as a matter of course that they wanted to do this. Then the modalities will be worked out through the lawmaking process. That's going back to talking about the consensus you earlier referred to. Not thinking that you know what is best for the people, but finding out from people what do they really want. Now, having done this, if the National Assembly now comes up with the draft, it will now go to the houses of assembly, which are required to also pass them before they will become amount to constitutional amendment. So you can be certain that with the buy-in of the governors on some of these issues, the constitutional amendment process will go on seamlessly. But where you do that at the center and expect them to accept them hook, line, and sinker, that's why you have state houses of assembly even rejecting financial autonomy, something that is good for them. They say, we don't want it. That's strange, though.
Are they really the ones rejecting it?
The governors. You don't want me to say that.
That's it. All right, okay.
Let me get to Ustaz Usman. I know that you've expressed some doubts about this process. Well, it's a process now that is ongoing. I agree with you as well when you said that sincerity is key, sincerity of purpose, because I could represent a people. I can even engage them on camera, and yet I don't take on board what they tell me when it matters most. So this process has started. It's the right process. How do we make this count, considering all the issues that are on the table?
Now, before then, please, I'm an old man. Only I'm not fat like Osigwe. But let me tell you, my experience so far with our leadership has been bitter. And how many more years again do I have to live? So I have to say what I want to say. Let me tell you, this is the first time in my life that somebody will say, I want to give you freedom. You say, I don't want. Local government autonomy. The local government say they don't want. House of Assembly. And you know the reason? It is because they are just houseboys to the governors. It's the governors who dictate to them. And unless we can extricate them from the grips of the governors who are wicked, not sincere, and want to continue in power, it will be difficult to have these things passed by the state houses of assembly. And that is your major work, lawyer. That is your major work. You will account to God when you die. That is your major work. Please try and do something about it. And then this issue, I told some senators who were my clients, I said, look, you are now there. What you should think about is not here. When you die, God will ask you. If this doesn't work this time around, then it is unfortunate. Then, I think, fortunately for Akpabio, I'm happy. He has not started badly. But the only thing they will do to make it work is to make sure that between them and their conscience and their God, they are doing the right thing. And then there is need for constant, like Osigwe said, consultation with the professionals. Advice. You have many intelligent people in our faculties and so on who can give you qualitative advice. And this lack of qualitative advice is what is causing our legislative output to be poor. We don't have this, and I hope Akpabio will work on this this time around. These people are not just there for nothing. You need them. The quality before now has been too poor. And if you look at it, the way we are going, everybody knows what the problems are, and I continue to drum it. Take this this national conference, this Jonathan something. Anybody who tells you it's not a good document is not sincere to Nigeria. Take these things, even if it is only these things, the German ones you can amend so far, Nigerians will be satisfied with you. But if you say you go and say this one, if you leave that document, you are not amending anything. That is the first document I myself am satisfied with. And I keep on reading it almost every month and advising people on it. That is the people's constitution.
All right. Thank you very much, sir, for your contributions there. Let's go back to Barrister Obuche now in Port Harcourt. Barrister, you have been listening to the conversation in the studio, I believe, and one of the major issues raised here is that actually it's not really about the constitution that has issues, but the people in government, the people that are running the constitution, they are the problem that we have. What is your take on that? And also concerning the Constitutional Conference amendment that was done during the time of Jonathan. What's your thought on that amendment as well?
Well, I'd like to correct that impression. The Supreme Court has said that the word barrister is not a title. It's not something you designate somebody who is practicing law as a legal practitioner. Well, to your question, I think the most important thing the National Assembly will want to establish is that it will take whatever constitutional amendment process it is engaged in beyond the realm of the circus and jamboree that it has been labeled with over the years, at least to attach some shade of seriousness in constitution making. We know the quality of debates in the National Assembly, and we know the gaps and inadequacies there. But then, the prime issue is that if you have a constitutional making process or amendment process, and within its institutional facets, there are areas of hindrance or areas of strongholds of barriers and obstacles, then of course something is wrong with that process. The gentleman in the studio from the National Assembly had stated that they have problem with getting the state houses of assembly to assent or to give approval to some of the issues that are affected, particularly on local government autonomy. We know the battle that was fought before the some state of autonomy was given to the judiciary. And when that happens, then of course they know something is wrong. But I believe that constitution making amendment process is a holistic thing. And when we are talking about it, we believe that anything worth doing is worth doing well. You don't go into have measures and expect very excellent results. By the way, some members of the House of Representatives had made proposal for the incorporation of parliamentary government, as a ready approach to involving an all-inclusive and viable constitutional instrument in the amendment process. And this should be considered. And when members of the National Assembly, House of Representatives specifically, make such proposal, of course you understand that they must have looked deeply, profoundly into these areas that need serious either amendment or outright scrapping or whatever. Whatever happens to the Constitution, it doesn't matter. But we should all look at the 1999 instrument as one that is, let me use the words of my colleague there, iron cast, or it is indispensable. If we want to make a very good start, we have to discard those ones that are irrelevant and those ones that are not necessary. To the very best of my knowledge, this suggestion by the members of the House of Representatives for a transition from one system of government or the other evidences the fact that there are so many things wrong with our constitution. If anybody tells me it's not wrong, I think I will want to disbelieve that particular person. And if you want to get it right, then we must get into the metrics of constitution making. That is my own point, and I believe that is the point of majority of the demography of this country, members of this country, population, that, well, there are so many things inherent in our constitution that need some tinkering. And that is also proof that the governance mechanism and all the ramifications of running statecraft has not been very viable and very, very okay. As far as I'm concerned, I think there's something that should get into the nitty-gritty of making a constitution in the proper manner that it should be made, in accordance with the principles of constitutionalism, in accordance with the sovereignty of the people, in accordance with the doctrines, all the relevant doctrines and principles of constitution making. And also, further to that, my learned senior in the studio, Usman Ustaz, he happens to be my senior caseman, and he has a lot of respect from me. He gave a very fine introduction as to the fact of the conferences. Those conferences are even superior instruments of dialogues, instruments of constitution, than even the current 1999 constitution, because it involved ethnic nationalities, and people spoke their minds unabatedly. There was total consensus. It's a factual proof. Those instruments are factual proofs of consensus. There's the Abuja report, the conference report, there's the Goodluck Jonathan conference report, there's the report of El-Rufai. No matter how worthless the latter is, I think it's something that should be considered as well. But these are things that should be carried along, and it's not for the National Assembly. I'm sure they are thinking along that line also. But to the extent that I understand, I think a constitutional making process should be made in a manner that accords with the principles of the Constitution, with constitutional making procedures that we know. The traditional system of democratic enthronement of constitutionalism must be followed, and not on wishy-washy grounds. They touch one particular area, touch that, and touch that. I mentioned the Electoral Act, not that it's part of it. It is also part of the Constitution anyway. But just to give an example of the implications of getting things done in a roughshod manner without considering certain intricacies that are very germane to ensuring that it is done perfectly. What we need as Nigerians now is a document that can stand the test of time. The amendment making process, I agree, is always a continuous thing. You cannot get a wholly perfect document, but let us try. And if it's anything worth doing, then we must get it right from the start and not tomorrow begin to talk about legitimacy, illegitimacy of the Constitution. You talked about the preamble and what it declared. A Constitution we cannot be talking here and there, cannot be playing Jekyll and Hyde at the same time. The constitutional instrument must be very frontal and direct. These are the basic issues that need some tinkering. As far as I'm concerned, Usman Ustaz has given it all the containments that it desires. That the conferences of Abuja, the conference of Jonathan, the RFI report on devolution, on fiscal federalism, on all those areas, state police will be put together in the course of these constitutional amendments to give it some shade of validity. And if they should continue, then the proposal by the members of the House of Representatives for a consideration of a transition from a presidential to the parliamentary system should also be considered along that line. It may not necessarily end in a change of the system, but at least to make inputs that will give some shade of legitimacy to our constitution, particularly in certain critical areas such as devolution of powers, structural imbalance, fiscal federation, and all that. Thank you very much for the opportunity.
Thank you very much, Festus Oguche, for your comments. Let me get back to Honorable Philip Agbese. Now, a lot has been said about the previous conferences, particularly the 2014 National Conference, which Yunus Ustaz has copiously made reference to. Is the House of Representatives or the National Assembly likely to consider, taking a look at the 2014 conference? The reason being that 492 delegates representing a cross-section of Nigerians, a broad spectrum, which even included professional bodies, it's not what you may have. I know that the House of Representatives has a lot of people, for instance, people across all, sections, all walks of life, but it couldn't be broader than the one that sat over the 2014 National Conference. Is this something that the House is willing to take a look at, and maybe by extension the Senate?
Thank you very much for that once again. If I say that the 1999 Constitution as amended remains one of the best instruments of governance, I'm very, very sure very senior persons, would want to argue with me. But my point for saying that will also be the fact that the document itself did not confer on itself, the powers that it will remain an everlasting document till the end of time. It is still in that same document that the imperfection was accepted and room was given in the wisdom of our founding fathers that at any point in time you are not satisfied with this document, that at the course of going forward into the history, into the journey of our country as a nation, we are no longer comfortable with certain instruments. We are allowed to go through this route, through this process, through this procedure, and we will be able to incorporate those new issues. I want to give it to the President Bola Ahmed Tinubu administration. For one thing, the Oroseye Committee report that is in the process of implementation was not done by the current administration. But a president with a foresight was able to look into the past and say, for us to move forward in time past, not necessarily our administration, not necessarily our government, not necessarily our party, but someone somewhere in the past was able to do something novel that will be able to address some of these issues. And I can tell you again that as a parliament, the leadership of Senator Akpabio as the Senate President and our counterpart, leader, His Excellency Right Honorable Tajuddin Abbas, were equally interested, that in moving forward, the history, the past of the country must be properly analyzed. And in doing that, That brings us to the issue of past constitutional conferences and even the various reports that we have today. So in the wisdom of this Constitutional Amendment Committee, we have set up a subcommittee that will look into those past events. We must not spend money on things that we have agreed as a people that we have rightly, done right. It must not be our time. But we believe strongly as a parliament, that the voice of the people, must be supreme. We see ourselves as servants of the people. And individually, we are people committed, to the things that we said to Nigerians during the electioneering campaign. And that is why, in the parliament today, you see, apart from the level of synergy and cooperation that you see between the various political parties, because we understand that being in parliament must be in the overall interest of the people. It must not necessarily speak into your ethnic coloration. It must not speak into the political party that you are representing. And that is why our debate has been very robust on critical national issues. We come together, to form this consensus as to the way forward. What best solutions do we apply to address these issues? So Nigerians are lucky at this point in time that they have elected representatives who also see the country as their own, who see the people as their masters. And it is in doing that that we're looking at these issues, that should form the nexus of a guiding philosophy called a constitution, in the raw interest of the masses. And again, when Ustaz SAN mentioned, the issue of people who are not ready to take up freedom, it wasn't easy, even with the judicial autonomy. But it was made possible through public advocacy and the commitment of the lawmakers. And that's exactly what we are doing. Nigerians need to know that part of the reasons why the country is not moving forward is because certain persons have refused to give way. That the governors have refused to allow the country move. So if we all know and we all believe and agree as a people that local government autonomy for the third tier of government to work and for development to permeate the grassroots, that there must be local government autonomy, we can do it. Even we as a parliament, we have the right instrument. Because the constitution confers on us powers to scrutinize even the allocation of resources. So we'll be able to debate some of these issues. We'll be able to map out strategic roadblocks to say if you are not interested in giving, and that is why I want to give it to the Right Honorable Tajuddin Abbas-led Constitutional Amendment Committee. Starting early is very key and important. Because what do you get when, towards the midstream of the parliament, after people have spent 2 years and when people are preparing for electioneering campaigns, political party primaries are taking place, you begin to talk about constitutional amendment. You'll be speaking only to those issues that will form the basis for which you can be re-elected as a lawmaker. But now this is time for governance. The first 2 years that people are elected, people should hit the ground running. And that's exactly what we are doing. This is the time for frank talk. This is the time that people will be able to look into the governors at the course of our meetings. We are going to make our meetings very public, particularly in engaging the states. Our interaction, at the state levels may not necessarily be about assembling the ethnic groups, but for the committees to be able to speak to the governors and say, from presence of opinion and what Nigerians are saying everywhere, Your Excellency, it is important that we look at the issue of local government autonomy. It is also important that we look into the issue of autonomy for the state houses of assembly. Some states have, commenced the implementation. El-Rufai tried it in Kaduna, local government autonomy. And we know, and again, it is the way that we operate the law that is important. Look at the issue of joint allocation committee. Even some states, some governors will pretend that there's local government autonomy, the money is sent from Abuja to the local government accounts. But what happens to the monies? The governors again use their cronies and allies as contractors and conduit pipe to take the money away from the local government. So these are some of the issues, and even without an amended constitution, we should be able to look at how these funds are being spent, the money going to the local government. And that is why in the wisdom of the current of the Speaker of the House of Representatives, he has constituted a committee called States and Local Government that will look into how federal interventions to the states and local government are expended. Because it is one thing to say we do not have powers as a parliament to go into the affairs of the federating states. But again, you are talking about money belonging to the whole country, sent to local government for developmental purposes. A case I would like to mention, the 774 local general hospitals that was awarded in the last year of former President Olusegun Obasanjo's administration. They've paid, from my investigation in the parliament, the monies for these contracts were paid before the exit of that administration. There's no local government in this country anywhere that any of those hospitals has been built, has been completed. These monies have been paid. Our committee on local, state and local government is already investigating that. So coming back home to the issue of constitutional amendment, I can tell you, we as a parliament, we are dutifully committed towards ensuring that in our time and within the shortest period of time, we bet a whole new document that those who are still around will be proud that yes, in their own time before, they left the stage, that truly their yearnings and aspiration as to what to be contained in the constitution is implemented. And beyond that, which is more important, is that when this document is accepted, we operate them like how constitutions are operated everywhere in the world. I'm talking about the issue of moving from the presidential system to the parliamentary system of government. I want to commend my colleagues, who are going around the country, because the sponsors of that bill, about 68 of them, and every day the number keeps increasing. They are going around the country talking to people. They say, we are here, we are direct beneficiaries, but we are looking at avenues, possible means to make Nigeria better. We are equally looking at the cost of governance.
Are you also considering the role of strengthening the role of the traditional rulers in this amendment?
Well, what exactly are supposed to be the roles of traditional rulers? Is it going to be in the interpretation of the Constitution? Is it going to be the implementation of certain roles and functions, that will be contained in the Constitution? That will be left for, the various committees working on that document. But as a matter of fact, I believe in the 3 tiers of government. And if these 3 tiers work the way they've been, programmed to work, we'll definitely have a better country. So the traditional institution is very important, especially, in the issue of state police and making sure that there is peace and harmony. But beyond that, I don't really see much that anybody can do if we do not own it as a country, to build, develop, and safeguard the future of our children.
Okay, thank you very much, Honorable. We'll now take a break. The discussion continues. Stay with us. You're welcome back. We are still on to Good Morning Nigeria, and our conversation today is on the constitutional amendment. And our guests, we still have our guests in the studio. Let me come straight to Osigwe, SAN. What more do you think the National Assembly can do to ensure a more friendly constitution? People-friendly constitution. What more do you think can be done?
Sir, laws are not self-executing. So whether a law is friendly or unfriendly, I don't know that. I don't really know what to make of that. Depends on how people implement them. And that goes back to what Yunus Ustaz said. It's about leadership. Leadership determines how a nation goes, a trajectory. Look at Dubai. I mean, it was a desert country like in the 60s. Today is a first world country. Look at Singapore. It took the personality of their leaders to drive the changes and the development you see there today. So they didn't sit down lamenting about the state of their laws, the harshness or friendliness of their laws. They put the people at the centerpiece of development and leadership. And they used their personality, and they were selfless. They saw the society as that which they should change to make for better living for their people, and they strove for that, and they achieved that. So it is not our laws. It is in us. The fault is in us. It is in our failure to make for a people-driven kind of leadership. We want to amass wealth that we don't need. We steal what we don't need. We steal money meant for building hospitals and die traveling to another man's country for health care. We steal money meant for roads and die in road accidents. We steal money meant for security and for victims of the insecurity. It's not the law. When we do the right thing, when we use law for the purpose for which it is meant for, when we use power for what it is meant for, the people, making them the centerpiece of our actions, remembering that there is due process of law, remembering that no matter how much you steal, at the end of the day you'll be lucky to get 6 feet. How much land do you really need? So it's about what is our attitude to governance. Do we see it as an opportunity to settle ourselves, to steal that which others have been stealing? It is now my turn to eat. We're at a dining table. It is the dining table mentality or attitude to leadership in Nigeria that is the bane of our problems. That's our problem. So if you, it's the laws that have worked elsewhere are imported into Nigeria and they fail to achieve the same objective which they achieved in other places. I've always said it is not the laws. We have world-class laws that can make us whatever we want to be. It's our failure of leadership. It is lack of altruism in leadership in Nigeria that has kept us where we are, that has made it difficult for us to develop as much as we should. People who came here to understudy some of the things we are doing here have done so well with them, and we are not. So I say again, the fault is in us. The fault is a failure of leadership, not a failure of laws. Even if you bring your beauticians to make our laws beautiful, and the people do not implement the laws the way they should be, they won't give you what they're supposed to give you.
Thank you very much. Let me come to Utsaz now. SAN. You have also talked about the issue of leadership. Running the constitution. That really the constitution is not really the problem. Even if the constitution is amended now, and you elect new people to come, we still have the same problem. Yeah. And some people have suggested that we should actually look at the issue of independent candidacy in this constitution. Maybe it will help to change a lot of things. What's your thought on it?
That is the first suggestion I made in my memorandum to the Constitutional Conference. And I've always said, if you don't want this money bags to continue, you need independence candidacy.
Yeah.
And please, Honorable, wallahi, I say wallahi. If you people do not take the National Conference something as your tool, I will campaign for Nigerians to reject your amendment. Wallahi, I say what? Maybe I don't even think I have more than 4 years to go. If I'm so what I need to get? And you see, I'm gay from my learned friend. Like Honorable said, the money meant for building hospitals, no hospital is there.
Money paid.
And you know, when people steal like this, I pity them. Let me tell you one thing people don't know. When you steal this money and you buy kose, kose akara, bean cake of 1 naira for your child out of it, wallahi, while you are still alive, that child will be useless. Tell me, and I say it to anybody without any apology, tell me the child of any former public office holder who had usurped public money, whose child is anything today you can think of, from presidency to governorship and so on. Tell me one. That is because they are foolish. They have touched the public money, use it to train them, take them to Oxford and something. When they come back, they even become threats to their parents. I know an air commodore whose son used his gun to kill him. Yeah, people are foolish. You don't need this money. People are foolish. Please think that public money is for public. If we should use public money well, we wouldn't have been where we are today at all.
So the issue of private candidacy should be really considered.
It should be really considered if we want people who are sincere to rule this country to come. And then chapter 14 in particular. Chapter 14 should be justiciable. That is, chapter 2. Courts should be allowed to say the governor, you must do this for your people, you must provide water, you must do this. Once it's not justiciable, then the courts cannot do anything and cannot force any governor who doesn't want to do anything to do, and the governors will continue to steal, even though anyone who does so is a very foolish person.
All right, let me get quickly to Festus Oguche in Port Harcourt. We've talked a lot about leadership. It seems that everybody is in agreement that leadership is a major issue. Now, the only way you can get leaders that will rise independent of the parties, the political parties that many think are part of the problem, is to create an opportunity for independent candidacy. What is your opinion on this? And do you think we are ripe, we are ready for independent candidacy? Because the cost of election is also there. Party bears some in terms of structure and all of that. Will an individual who is not a money bag be able to stand election on his or her own and make headway?
I must first of all commend my kinsman, Ustaz Usman, for hitting the nail on the head and raising a lot of critical issues that require adumbrations here. I will, before I go into the issue of the independent candidature, you talked about leadership. The leadership question has dogged Nigeria's, has been at the apex of Nigeria's problems since independence. And there are no two ways about it that we have to look at the process upon which leaders emerge. If you are talking about the constitution, I know that you can take this constitution elsewhere, where people are serious and it will work. But if you're talking about the constitution, look at the hollow effects, the inadequacies of that instrument, of that document that makes it possible for irresponsible people to come on board as leaders. So long as we have an electoral system, an election procedure that is not credible and transparent, that could allow a single person to sit down and declare somebody as president, then of course you know that you can never have the kind of leaders that this country deserves for a proper running. If you look at the spectrum of the generality of the Nigerian population, you find people with high level of credibility, high sense of integrity, who can be put into leadership positions and they deliver. There are so many, you know. Then again, you see it from the position of a constitution that will allow the level of graft or corruption that we are witnessing now. A constitution that will literally make the National Assembly go to beg the governors to allow for local government autonomy. I mean, it tells you a lot of things about its absurdity. So many things. Said nobody has talked about the issue of judicial reforms. I think Osman Ustaz raised it. But judicial reforms is also imperative, because when we have problems with the judiciary, when the judiciary becomes the clog in the wheel to justice, then it creates a myriad of problems that you cannot triumph over. And that's the thing. So many things are involved, but then the issue of getting the people along, carry them along in the constitutional amendment process, as to have an integrative process toward the making of a people's constitution is very imperative. There's nothing they will do now that I will ever be impressed, because at the end of the day, it will boil down to the same thing. On the issue of independent candidature, I don't think it's something that we should enact in any place in the constitution. The African Court of Human Rights, the African Court of Justice and Human Rights had given a judgment in the case of Reverend Mitilika against the Republic of Tanzania, stating that denial of a person to contest as an independent candidate in an election is a denial of the right to participate, of his right to participate under Article 13 of the African Charter. First, the court went ahead to state that forcing somebody to join a political party is a denial of his right to freedom of association. That's in the case of Reverend, there are lawyers there, Reverend Ntilika, you can Google it. Reverend Ntilika and the Tanganyika Bar Association versus the Republic of Tanzania. Nigeria is signatory to that, the instrument that established that court, and so it is subject to its jurisdiction. We don't have to go begging Nigeria to allow the federal government to allow Nigerians access to that court, because you and I cannot have access. If the Nigerian police violates my fundamental rights here in Nigeria and I want to go to challenge it before that court, I have to seek the permission of the Attorney General of the Federation. The particular person who violated your rights is the one that to give you permission or license to go to that court, is the one also to represent you as counsel. You see how topsy-turvy the whole thing is. But then on the issue of independent candidacy, that court has given that judgment and Nigeria is bound by it.
Well,
all right.
Thank you very much, Festus Oguche, for that. Because of time, we have to cut you off there. We really apologize for that. But before we go, let's just take a word from Honorable Agbese there. What assurance are you giving Nigerians now that this constitutional amendment will be seen through? What assurance do we have from you on behalf of the National Assembly?
Yes, I want to solicit their understanding, their cooperation, and to plead with Nigerians, to, for the last time, once again, have faith, in the present leadership of the National Assembly. We know exactly what to do, to make the country work. And we can assure them that their opinions would definitely count in what we're about to do.
Thank you very much, sir. You know what to do, and their opinion will count. Okay, Victor.
Philip Agbese, thank you very much for coming on Good Morning Nigeria. Chairman or Deputy Chair, House Committee on Media and Publicity, Subcommittee Chairman, House Committee on Constitutional Review. Thank you for coming on Good Morning Nigeria. Leonard Silk, Yunus Ustaz Usman, thank you very much for your time and insights. And Afamo Sigwe, former Secretary General of the NBA, we thank you for coming and even staying beyond what you said you would stay. We appreciate your time.
Thank you so much.
And that's Good Morning Nigeria for today. We thank you for keeping us company. I am Victor Azu.
And I am Ademola Adio. We appreciate you joining us. Join us again tomorrow for another episode of the program. Enjoy the rest of the day. Thank you.